Welcome to the course Introduction to Urban Planning. In today's session, we are going to discuss about growth and evolution of planning legislation, and specifically we are going to talk in the context of USA, and we're going to walk through this legislation journey of USA to understand about the development and understanding we had developed in this course of time, and how various planning laws and legislation came to address those requirements. While we go through this lecture, I would request you to reflect upon our aims and objectives of planning, and also link the sustainability and planning issues, as well as look at all the contextualization series lecture which we went through. So in this, we see that key transformation which happened through the Act. For us, the key reference for us would be American Planning Association publication for this particular lecture. Accordingly, the coverage would include that we are going to walk through the timeline of USA planning legislation from 1700 to nearly 2020. And our learning outcomes would be that while you go through this legislation, you should be able to review how our understanding about the community, environment and planning was evolving, and how we addressed it through legislation. You should be able to connect it with the other part of the world, how the legislation was evolving, as well as you should also look at the future direction for this. Let us briefly look at the early timeline of US legislation for the purpose of locating ourselves in the domain of urban planning. One of the most prominent difference between European and American city is vast available land area in the USA in comparison to what we saw in the previous lecture, in comparison to Europe, where the density was very high. So we see that here there's a lot of availability of land, and then there's also car-oriented cities. First, looking at 1785 Planning Land Ordinance. This was an ordinance which was adopted on May 20th, 1785, which laid the foundation of American land policy until the passage of Homestead Act in 1862. After the Indian title had been purchased, the surrendered lands were to be systematically surveyed prior to sale or settlements into townships 6 miles square. So this was the time when they started documenting the land and started to sell the land for the purpose of settlement. Later we see in 1855, first model tenement act built in Manhattan. And later we see in 1862, Homestead Act opened lands of the public domain to settlers for a nominal fee and 5 years residence. So this Homestead and Morrill Act of 1862 in US history was a significant legislative action that promoted the settlements and the development of the American West. It was also notably for the opportunity it gave African Americans to own land. So people could own land with this with a nominal fees. President Abraham Lincoln signed the Homestead Act on May 20, 1862, and on January 1863, Daniel Freeman made the first claim under the Act, which gave citizens or future citizens up to 160 acres of public land, provided they live on it, improve it and pay a small registration fee. The government granted more than 270 million acres of land while the law was in effect. So we see here the document of the Act here. Later we see in 1864, New York Council of Hygiene of the Citizens Association mounts a campaign to raise housing and sanitary standards. In 1867, first major tenement house law, particularly New York, comes, which restricts the physical condition. And later we see in same time in San Francisco, which prohibits specific obnoxious uses in certain districts beginning of land use zoning. So we see that in the same time you're seeing that we are coming up with tenements house law, which is focusing on how the physical condition would be for the people who live there. As well, we see that in San Francisco, now land use zoning is being coming into picture, which is prohibiting certain land uses. Later on, we see in 1879, the Dumbbell Tenement Act, which comes in, a form of multifamily housing widely built in the New York and notorious for poor living conditions. So you see that dumbbell tenement, which comes up in 1879, which is very well known for its poor living condition, and it was like kind of a multifamily housing which was widely built in New York. Later we see in 1880-84, building of Pullman, Illinois, a model industrial town by George Pullman here. In 1879, you see that there was old New York tenement house law. As per the Tenement Houses Reform from the Social Welfare History Project, in the late 19th century, the public began to comprehend the extent of terrible living conditions enduring by the immigrants and the working class poor in the New York City. The Tenement House Committee, formed in 1898, would lead to creation of New York State Commissions that oversaw passage of the New York Tenement Act of 1901. So in 1890, How the Other Half Lives by Jacob Riis was published. You may recollect our Contextualizing Cities series where we looked at the pictures. So this was published and it was very powerful in moving people to understand the lives of the people who lived there. Because of this, in 1901, New York State Tenement House Law came into picture, which is the legislative basis for the revision of city codes that outlaw tenements such as dumbbell tenement. So that dumbbell tenement was removed after this 1901 New York State Tenement House Law. If we look deeper into this particular tenement law, as per the Tenement House Reform from the Social Welfare History Project, the New York State Tenement House Act of 1901 was one of the first laws to ban the construction of dark, poorly ventilated tenement buildings in the state of New York. This progressive era law required new buildings to have outward facing windows, indoor bathrooms, proper ventilation and fire safeguards. Prior to the passage of this law, dumbbell tenements with tiny apartments opening into the air shafts were common. Tenement houses built after the passage of the New York State Tenement House Act of 1901 are sometimes referred to as a new law tenements. The New York State Tenement Act of 1901, or the New Tenement Law, was the housing reform law aimed at improving living conditions in New York tenement buildings. Technically, a tenement, if you look at the meaning of tenement, was any building that housed 3 or more families, but the term had come to mean housing for poor families that lacked proper amenities. We see that the law sets requirements for new buildings to improve light and air quality for residents, including external facing windows in each room, an open courtyard, improved ventilation, indoor toilets and better fire safety. Moving forward, we see in 1906, Antiquities Act came. In this, the President Theodore Roosevelt signed the Antiquity Act into law to preserve archaeological sites on public lands. So we see that how we have started taking care of all the heritage which is there. The act also authorized the President to protect landmarks, structures and objects of historic or scientific interest by designating them as natural monuments. So you may recollect we also saw such kind of provision in UK. We will also see in Indian context. It was a landmark in the preservation of historic places and structures as well as cultural resources. Devil's Tower in Wyoming was the first monument to be protected under the Act. Moving forward, we see that in 1907 in Hartford, first official and permanent local planning board was formulated. So, Hartford in Connecticut, we see that it recognized how the planning commission would come in. Further, we see that in 1907, in Hartford, Connecticut, first official and permanent local planning board was set up. Hartford, Connecticut today is recognized as the pioneer in the city planning field, as it had the first permanent city plan commission in the United States. Moving forward, we see in 1909 in Los Angeles, first land use zoning ordinance was passed. It was the first American use of zoning to restrict future development in Los Angeles. So, we see how that through land use zoning we are exerting more control over the usage of land. Later in 1916, we see in New York first comprehensive zoning ordinance, comprehensive zoning resolution was passed. Zoning resolution was written by George McCanney and Edward Bassett as a response to concerns about overdevelopment in New York City. So, based on that, the resolution divided the city into zones based on the primary activity in that area and created building heights and setback guidelines for each zone. It is considered the first citywide zoning code in the United States. So, you see kind of a building regulation coming in where it is determining what kind of building height and setbacks would be given. So, that happened in 1916 in New York City. Moving forward, we see in 1923, we see that Standard State Zoning Enabling Act was issued by U.S. Department of Commerce. So, the U.S. Department of Commerce committee issued the third draft on the Standard State Zoning Enabling Act, which was a model law developed to help states create zoning restrictions in their jurisdictions. So, it created a model law and guided the states how they can create zoning for their own states here. This draft contained important language defining a zoning commission and calling for a plan for zoning regulations. This was followed in 1927 by a Standard City Planning Enabling Act to help states understand the organization and power of city and regional planning commissions, the making of the city and regional plans, and controlling the layout of new subdivisions. These acts still provide the institutional structure for planning and zoning in many states. Later in 1933, we see National Planning Board was established under the authority of Public Works Administration. The board, which included Frederick Delano, Charles Merriam, Wesley Michel, and Charles Eliot, worked to promote the idea of planning in public works and push for comprehensive regional plans. So, we had seen comprehensive regional plans also in our previous lectures. So, this came into formal system in 1933. Over the next decade, the National Planning Board evolved into National Resource Board, the National Resource Council, and finally the National Resource Planning Board. Further, we see in 1948, we see that the American Institute of Planners published an early code of professional conduct for planners, focusing on the profession's responsibility to public, the client, and other planners. This code of conduct was revised many times, but eventually became the current AICP Code of Ethics and Professional Conduct. Later on in 1949, we see Housing Act came up, Housing Act, Wagner-Allender Taft Bill. It was the first comprehensive housing legislation which aimed to construct nearly 8 lakh housing units and inaugurated urban renewal. So, you see how urban renewal initiatives started taking place. Majorly through this act, it provided funding for urban redevelopment. Later on, we see in 1949, US Comprehensive Housing Legislation Act came up as a part of President Harry Truman's Fair Deal initiative. It allocated funds to improve housing in urban areas, especially for American poor, in hopes of countering the effects of suburbanization. If you remember suburbanization, a lot of elite people were moving out of the core city. The Act's main element included slum clearance and urban renewal, building more public houses, and expanding Federal Housing Authority mortgage insurance. Expanding Federal Housing Authority mortgage insurance. The Act has been criticized. You remember that it was rolled back. So the Act has been criticized for ultimately eliminating more housing than it created, as well as for destroying cheaper housing in the minority neighborhoods and replacing it with more expensive alternatives that residents could not afford. However, it also made open space land, neighborhood facilities, and basic water and sewer facilities eligible for federal assistance. So we see that funding started coming for all these kind of things. Later on, we see in 1954 Housing Act came, which stressed slum prevention and urban renewal rather than slum clearance and urban redevelopment. It stimulated general planning for cities under 25,000, Section 701. Funding later extended to statewide, interstate, and sub-state regional planning. The Housing Act of 1954, managed by the Federal Housing Authority, provided funding to support urban renewal and slum prevention as opposed to redevelopment. The legislation also created programs which funded planning assistance for communities, contributing to the spread of planning and comprehensive plans throughout the United States. The program originally targeted small local governments, but it was so popular that it was gradually expanded to cover almost all jurisdiction types in the country. Further, we would also see that at the same time, we see Supreme Court rules on eminent domain. In the case of Berman v. Parker, the US Supreme Court ruled that Congress can seize property for any public purpose under eminent domain. The case centered around the District of Columbia Redevelopment Land Agency seizing property for the purpose of beautification, which appellant had argued violated the Fifth Amendment's taking clause. So you see how a planning intervention can have conflict with the rights of the people, which we discussed in our initial lecture. Later in 1956, we see that Federal Aid Highway Act came in. President Dwight Eisenhower signed the Federal Aid Highway Act, or the National Interstate and Defense Highways Act, into law, with a plan to fund nearly 41,000 miles of interstate highways over a period of 10 years. Under the Act, 90% of the construction cost came from a highway trust fund, while states paid the remaining 10%. The Act contributed to an increase in driving by Americans as well as to the growth of suburbs and the decline of cities. So you had seen how we had car cities, car suburbs, and so on. So that was all interlinked with this thing. Later in 1961, we see Housing Act came in. This Housing Act was approved by President John Kennedy, authorizing nearly $5 billion in new funding for a wide array of housing programs. This included funding for acquiring open space, land, improvement of mass transportation, urban renewal, and building farm housing. The American Society of Planning officials welcomed the act as providing opportunities which was never possible before, and it also provided opportunity for coordinated planning of community development. In 1964, we see that Urban Mass Transportation Act came in. This was by President Lyndon Johnson's Urban Mass Transportation Act. It provided funding for mass transportation projects in cities. It also created the Urban Mass Transportation Administration, later the Federal Transit Administration. The act shifted the primary mode of financing mass transportation projects to federal grants and loans. So you may recollect our contextualizing cities lectures as well here. Further moving on, in 1964 we see that there were creation of community action programs, CAPs. So, Title II of the Federal Economic Opportunity Act established community action programs which were aimed at eliminating poverty. The programs were controversial because they gave the power for deciding how money would be allocated to the community's impoverished population as opposed to elected officials. So, there was conflict, although CAPs, community action programs, were generally ineffective because of high expectations and insufficient funding. Among other issues, they raised awareness in the planning fields of the need to include the community and look beyond mere physical redevelopment to social, economic and political development as well. Later in 1965, we see the HUD, Housing and Urban Development, was launched. The Department of Housing and Urban Development Act of 1965 created the U.S. Department of Housing and Urban Development as a cabinet level agency. So, you see how the agencies are now created at different level. Robert Weavers was the first secretary of the department, making him the first African American appointed to a cabinet position in U.S. government. HUD's mission was to make sure that there is equal access to housing and community-based employment opportunities, as well as to fund new housing, public housing and housing rehabilitation projects. The department also ensures mortgages and projects consumers. HUD is an important source of financing for planning projects. Later in 1966, we see that National Historic Preservation Act came into picture. This act was signed to protect historic sites from development. It was a response to the impact of urban renewal and highway construction on important landmarks in urban areas. The act also established the National Register of Historic Places and National Historic Landmarks program. Many communities now consider historic preservation through standalone plans or as part of a larger comprehensive plan. In 1966, we see that Model Cities program came up. The Demonstration Cities and Metropolitan Development Act of 1966 was signed into law by President Lyndon Johnson. The act, which was aimed at the urban renewal, established grants that would pay as much as 80% of the cost of developing city, demonstration programs and technical assistance from the Department of Housing and Urban Development. The Act's Model Cities program funded the cost of developing and implementing comprehensive plans as well as providing education, job, recreation and leadership opportunities for inner city residents. Later in 1968, we see Fair Housing Act came into picture. Title 8 of the Civil Rights Act of 1968, also known as the Fair Housing Act, was signed into law. The act prohibited discrimination against a property renter or buyer on the basis of race, color, religion or national origin. Gender was added in 1974 and disability and family status in 1988. So, you can see our initial lecture we talked about inclusivity, about people of different race, color, religion, orientation, so on. So, we see how in the act it happened in 1968, eventually in 1974 and 1988. The act was heavily and contentiously debated in Congress, but President Johnson put pressure on the legislators to pass it after the assassination of Martin Luther King Jr., although the Fair Housing Act and other initiatives helped reduce racial segregation by community slightly over the following decades. Many studies continue to show heavy segregation even now. Later in 1968, we see that Housing and Urban Development Act of 1968 established Ginnie Mae to provide additional mortgage funding for moderate income families. The act also allocated $250 million in funding for new town projects. The towns funded under this initiatives were Jonathan, Minnesota, Park Forest South, Illinois, Flower Mound, Texas, and St. Charles, Maryland. Further, we see in 1970, by this time, and when environmental consciousness started getting strong, so we see by 1970, National Environmental Policy Act came into picture. It created a mandate for federal agencies to consider environmental impacts when making decisions on any project that involves federal funding, work performed by federal government, or permits used by the federal agency. National Environmental Policy Act, also abbreviated as NEPA, is considered to have opened the door for later environmental legislation such as the Clean Air Act of 1960, the Clean Water Act of 1972, the Coastal Zone Management Act of 1972, the Endangered Species Act of 1973, and the Superfund Act of 1980, among many others. Collectively, these acts established significant new national requirements for environmental protection. So, in 1970, we see Environmental Protection Agency was established. President Richard Nixon proposed the creation of Environmental Protection Agency to examine and counter the impact of humans on the natural environment. The EPA, Environmental Protection Agency, administers federal environmental regulations that can impact planning projects, such as an environmental impact statement. You must be familiar with environmental impact assessment, EIA, or an environmental assessment in the US context. Later in 1971, we see the court case related with zoning ordinance being exclusionary. So, in the case of Oakland at Madison, Wiz Township of Madison, a New Jersey judge ruled that Madison Township's zoning ordinance was illegal because it prevented as mainly as 90% of the region's residents from getting house in the township. This was the first time that the zoning ordinance was completely invalidated for being exclusionary. So, as discussed before, how your planning interventions can have negative impact of the people and when it would be really bad for the community is an important judgment to be made. So, for that we look at all legislation and the legality of the planning process. So, here with this example you see how the entire zoning ordinance was considered invalid and was considered exclusionary. Further, in 1974, we see the establishment of Community Development Block Grant Program. The Housing and Community Development Act of 1974 created the Community Development Block Grant CDBG program. Under this program, a block of flexible community development fund is distributed annually using a formula that considers community population, poverty, age of housing, housing overcrowding, and growth tag. The Act also created Section 8 Housing Support, which provides housing rental assistance to low-income household and the first federal urban homesteading initiative. Later in 1977, we see Community Reinvestment Act. So, we see that President Jimmy Carter signed the Community Reinvestment Act into law to address discriminatory lending practices, including redlining practices that prevented racial minorities from getting housing loans. This issue was brought to the fore by community activist groups led by Chicago-based National People's Action. Research has shown that Community Reinvestment Act was successful in increasing loans in low to moderate income neighborhoods, although it is not clear to what degree. Further, in 1978, we see the first state with statewide zoning coming into picture. The Hawaii State Planning Act made Hawaii the first state to institute zoning across the state. The statewide planning system created under the act included policy, planning, implementation and monitoring. Further, in 1978, we see a very critical court case. This was between Penn Central Transportation versus New York City. We also saw it in our previous lecture. So we see here our understanding further develops about how there can be conflict in the planning process and the objectives. We see that the US Supreme Court ruled in Penn Central Transportation Corporation with New York City that restriction on the development due to historic landmark status do not constitute takings. Means it's not taking away the rights of the people. Penn Central Transportation had planned to build an official structure on top of the Grand Central Terminal in New York City, but was prevented from doing so because the proposal involved demolishing part of the historic building and changing its character. The company argued that it deserved recompense because the city's decision constituted a regulatory taking or denial of a reasonable economic use. Further, as our environmental consciousness is increasing, we see in 1982 Habitat Conservation Plan Amendment coming into picture. The National Endangered Species Act of 1973 was amended to allow possible exemptions when developers create a habitat conservation plan to protect wildlife while developing a protected area. They are submitted as part of an application for an incidental take permit and described anticipated effects of the development, how developers will minimize these effects and how it will be funded. In 1985, we see second wave of growth management. Florida passed the Local Government Comprehensive Planning and Land Development Act of 1985, requiring that local government plans be consistent with the state and regional plans or risk losing funding. So, we had seen in our lecture different levels of plans and how our different levels of plans, types of plans need to be consistent with the higher levels of plans. Like the perspective plan, like the regional plan or the development plan. So we see here that through this act it was emphasized that the plans need to be consistent with the other higher level of plan, otherwise they might lose funding. The act is seen by some as a start of second wave of quiet revolution in the land use laws in the United States, which included Delaware, Maine, Rhode Island and Vermont passing growth management laws. Later in 1986, we see low income housing tax credit being launched. The low income housing tax credit was created under the Tax Reform Act of 1986, giving tax incentives to companies that develop affordable housing. For some estimates, the credit is responsible for about 90% of all affordable housing built in the United States. Further, in 1990, we see Americans with Disability Act. President George H.W. Bush signed the Americans with Disability Act into law, protecting Americans from discrimination based on their physical or mental disability. So you see that how eventually we are going on making our planning more inclusive by having all these acts in place. Further, in 1993, we see federal enterprise zones and empowerment communities. The Omnibus Budget Reconciliation Act of 1993 included legislation creating empowerment zones and enterprise communities for the first time at the federal level. These designations applied to specific distressed urban and rural communities and were intended to encourage comprehensive planning and investment by providing tax incentives and social service funds. Later in 2000, we see that Disaster Mitigation Act came into picture. The Disaster Mitigation Act of 2000 was the first disaster relief bill to emphasize mitigation, or taking a proactive approach to reducing the impacts of a disaster before it happens. Under the Act's Hazard Mitigation Grant Program section, communities that had received presidential declaration or disaster could apply for grants for disaster mitigation. The Act also included new requirements for state, local and tribal entities to coordinate mitigation planning and implementation efforts. Later in 2005, we see another important court case. We see the court case of Callow with City of New London in United States. Supreme Court ruled that private redevelopment plans qualify as a public use for taking if they provide sufficient economic growth benefits to a community. So, we see here that even for the public purpose, the private developers could also undertake projects. The case centered on the use of eminent domain on properties in New London, Connecticut as part of the economic development plan based around a pharmaceutical research facility. The state laws based on the ruling made planning more publicly visible and suggested that eminent domain needs to be tied to the broader planning process when used. Later in 2012, we see expansion of housing discrimination laws. In this time, we see U.S. Department of Housing and Urban Development published the rule equal access to housing in HUD programs regardless of sexual orientation or gender identity. The rule prohibited discrimination in HUD-funded housing and programs on the basis of sexual orientation and gender identity. It also prevented the judgment on homeless assistance, housing based on a person's marital status, sexual orientation or gender identity. Later in 2017, we see that mass-produced self-driving cars came into picture. General Electric announced plans to begin mass production of self-driving cars with sales scheduled to begin in 2019. The company said its car will be utilized as fleets of autonomous robo-taxis. Planners across the country are working to accommodate the amending reality of self-serving driving cars in their transportation plans. So, we see here driverless cars, and after this 2019, we are in the domain of pandemic, about which we have seen specific dedicated series of lectures. So, this was the journey about the US legislation so far. So, you have seen how from selling of the land to going for building public projects to going for low cost housing, urban renewal and going for tax rebate, and then being more inclusive for gender, inclusive for sexually differently oriented people, so on. So, we see how the legislation has been expanding to be inclusive. So, we saw all that today, and we also saw about how we also got environmentally conscious, and then also we see further that how technology is also changing our planning interventions. So, that is what we covered today. Our key references were APA documents today. Our coverage was limited with the scope to make you aware of the topic. There are enormous readings and movies available to explore. Few are suggested here. This is not an extensive list. You may feel free to suggest more from your experience. Please feel free to ask questions. Let us know about your concerns you have. Do share your opinion, experiences, and suggestions. Looking forward to interacting and co-learning with you while exploring cities and urban planning. That's all for today. Thank you.